People power growth, but recruiting and onboarding are expensive, exhausting, and absolutely overwhelming. I've been there, and it doesn't have to be this way. Welcome to Hire and Empower. I'm your host, Molly McGrath. Join me as we interview leaders who care about their teams and distill powerful lessons from them. This show is sponsored by H&E, helping organizations to find their best hire and empower them for success. Learn more at hiringandempowering.com. I cannot wait to see the number of downloads that we have for this episode today because I get questions all the time about at-will states, terminating employees, and I'm not the expert, and I definitely never answer that question because it is not my strong suit, and you do need to know what you're doing. So I'm so excited that we have Carly Wannos, attorney, here today. We're going to have all of her links to her LinkedIn, to her YouTube, to her website, to her podcast in the show notes. But we are talking about today terminating employees not so fast, and how to handle and terminate employees, especially at-will employees. And these are questions we get all the time. People are like, we're an at-will state, so I am A-OK. And I assert that attorney Carly Wannos is going to tell us differently today. So Carly, thank you for being our guest.
Yes, thank you so much, Molly, for having me. I
Oh,
appreciate it.
yes.
I can't wait to get into this discussion today.
Me neither. And you were just telling me that you're doing, preparing a presentation and you are speaking on this topic. It is a hot topic that you are constantly asked about, correct?
Absolutely. I'm just preparing a presentation. I live in Florida, so I'm presenting it to the Palm Beach County SHRM for their annual conference. And this is such a hot topic, and it's misunderstood by a lot of employers for the exact reason that you mentioned. Because a lot of employers think that if they're in an at-will state, they can terminate at any time. And there are some things that we're going to discuss today that's not always the case, right?
Yeah. So give our listeners a little bit of backstory in regards to your practice area and why you're so passionate about what you do.
Yes, so I am an employment attorney in Florida, and I have been for over 15 years. I strictly practice employment law. I represent companies and work directly with office managers and HR representatives. I really enjoy helping them to come up with a proactive plan to help them engage in best practices to avoid lawsuits against them. Lawsuits can obviously be devastating to employers. They're very expensive. They cost, a lot of money. They take a lot of time, not only your time as the employer, but also your employees' time, right? If we have to call them in for depositions or questioning or interviews, it really can be devastating to a company. So I enjoy not just dealing with the fallout of what might happen after litigation, but also really engaging in those preventative measures to make sure everybody's on the same track and to hopefully protect the company from claims going forward.
I can imagine, especially since the pandemic, that your phone and email is just absolutely blowing up. How often do you see employers, by and large, my audience is law firms. How often do you see that they feel like they have their ducks in the row, and once you get in there, you realize that they don't?
It's all the time, really. It's a lot. And really it's just because they are unaware, they don't know, or they might have an office manager or other managers who are on the front line dealing directly with their employees, and they're just not properly trained, right? I mean, they don't know what the law says. They don't know certain things that are going to trigger an obligation by the employer to take certain actions, right? When somebody reports a claim of harassment, there's something that needs to be done. There's an investigation that has to take place, things like that. And a lot of times the employers are just not aware, and they're not made aware until, unfortunately, after the fact, when, a lawsuit is filed. So
Ah, and my goodness, I'm just shocked at how many law firms when it comes to this, and they call me, I'm like, I don't know. I'm not answering that question. No way, Jose. Talk to us a little bit about this topic, terminating employees not so fast.
Okay, so a lot of states are at will employment states. And I think a lot of us, a lot of companies and employers know the first half of what that means, which is I'm an employer in an at will state. I have this employee and I can fire them at any time for anything. And on the flip side of that, the employee can leave at any time, right? But there's more to that at will definition. And it is an employer can terminate an employee at any time for any reason or no reason, right? Because the company doesn't even really have to give a reason, as long as it's not in violation of the law. So that's the second half of it that the employers sometimes miss. It can't be in violation of the law. Well, what the heck does that mean, right? Most times it means it can't be discriminatory or retaliatory. So for the employers, yes, if you're in an at will state, you can terminate an employee at any time. You need to make sure that you're not engaging in discrimination or retaliation when you do it, because that's the most popular, frequent type of claim that we see when there's a termination. And by the way, it's just not a termination, it's really any type of adverse action that you're going to take against the employee. So it's a change in their pay, a decrease in their pay, a failure to promote the employee. I mean, these are all things that companies can do that can result in a retaliation claim. So you just need to be aware of that.
So I love that you just talked about it's not only a time of termination. So you check all the boxes, you make certain it's not discrimination, retaliation at time of termination. But what about any kind of quote unquote evidence that an employee has leading up to the termination that they could, stake a claim that it was cause for termination? Can you talk about that a little bit?
So the other times where you could have a claim of retaliation that's not just a termination, is that what you mean?
Yeah, so it's not
Okay.
at time of termination. You're really clear. You look at this amazing checklist that you have, listen to this podcast, get really well versed within your podcast, and you feel like you're good when it comes at the time of termination. You're clean, you're clear, and you feel like you're not in violation. Is there anything that they need to be thinking about prior to that termination that could be possible, quote unquote, evidence?
Yes. So and you mentioned my checklist. So on my website, I have a kind of a termination checklist. And these are some of the things that you can go through to make sure that there is not a potential for a retaliation claim, right? So has there been a request for a medical leave recently, a job protected medical leave? That's something that could possibly trigger a retaliation claim. Has there been a complaint about overtime? Right? That's something that could potentially trigger a retaliation claim if you then go ahead and fire the person. So, to your point, one's taking it one step further. Do you have to have a reason to fire the employee? No. Is it best practices, of course, to have your legitimate, non discriminatory reason? Yes. And the best way to do that is through documentation. I think employers hear all the time document, document, document. Documentation is so important. And that's because in employment cases, it's a lot of he said, she said, right? You did this. No, I didn't. You said that. No, I didn't. Right. So the way to get around that is through documentation. And that's what's really going to help your employment lawyer, your defense attorney to defend against a case if it should arise in the future. So you're going to want to have your documentation. Was this employee performing poorly? Right? Was this employee doing something they weren't supposed to be doing? These are all things that are going to create that evidence, like you said, the defense in order to defend against a potential claim. There's also a second part to that, The documentation is helpful for the defense of the claim, but also for purposes of transparency with your employee. So you obviously, if there is a disciplinary issue going on, you want to make sure that the employee is aware, right? You are not meeting your standards. You need to improve. You need to get back on track. You're violating this policy, et cetera. The documentation is going to help you to work with that employee to get back on track so that you're not in a point where a termination has to result, right? Because I don't think any employer really likes firing its employees.
No.
Of course, it would like to keep its employees, avoid that, turnover and costs associated with having to hire another employee. So that's the other part of the documentation that's helpful as well. It keeps everybody on the same page, creates that transparency with what's going on.
So, oh gosh, I have so many questions. You use this terminology, documentation, which attorneys are huge fans of. Talk to us like a little about it. So Susie, and I'll give you a real quick fact pattern that's real as yesterday. I have a client and they call me and they're like, Susie called and texted in sick again today. She's supposed to be here at 9:00. 9:20, she's like, I'm sorry, blah, blah, blah. And this is habitual and it's been happening. Like texting, like that's your policy for, well, no. Well, what is your policy? Because I had said at this point, okay, this has been going on since the day you hired her. It's probably time to let her go. But this fact pattern, there's no documentation other than a text stream. And the attorney, I said, well, what was your response? And she's like, what am I going to say? I said, okay. So using that scenario, which I think with hybrid, remote, this day and age of 2022, people are so used to leaning on doing Slack channels or Teams or texting or what have you for calling in sick, showing up late, whatever it might be, which are the common reasons I hear for termination.
So texting is okay from a legal perspective, right? It's something that's in writing that if you need to print out and put into a file, you can do that. That's fine. The problems that I have with texting is that, so are you texting off of a personal phone or a work phone? Because if it's a personal phone and that person leaves, the company doesn't have access to it, right? Text messages can also really easily be deleted, and we have difficulty a lot of times locating the text messages. I think if you delete a text message and it's after a certain amount of time, I think it's really hard to retrieve, especially on a personal phone. Also, text messages are typically more informal. So people get a little too relaxed on the text message, right? And they forget that they're still, especially for law firms, you're in a professional setting. I think that when you're behind a computer and you're sending an email, people tend to be a little bit more professional. A text message, we see that people kind of say things that they maybe shouldn't be saying. They use some slang, they use some shorthand. So when you have to print out this text message and show it to a jury, that can make things a little bit difficult as well. So I guess to answer your question, it depends on the policy of the employer. If they say no text messaging, you need to call in or you need to email in, then that's fine. They need to follow the policy. But if you want to allow text messages, that's okay too, but just be careful and be aware that you might not be able to retrieve them at a later time, like you could in email.
Yeah. And also the response, being really clean and clear with your response as an employer, in this case where they constantly are replying, okay, or thank you, or what have you, but that's not the case. And that ultimately is probably going to be the reason that this employee does get terminated because of the habitual late and calling in sick, texting in sick. And the response from the employer is consistently, okay, thank you.
Okay, fine. Thumbs up emoji, right? I mean, what does that mean? So we all speak in emojis now.
So tell us a little bit about the things that attorneys, that entrepreneurs, that business owners, that employers should be aware of right now in regards to termination, and what you would recommend either during the process of from hire to fire, what they really should have in place of being aware of? And, what do they always say? I always hear this statement that, whatever email you send or what have you, just assume that it's going to be on a jury trial. And so I love that. I do love that statement because it makes people be a little more conscious and aware and present in their tonality, messaging, what have you. But I like this thought process for employers, especially me. I have a lot of 1099 employees, not necessarily traditional W-2. My company's 100% remote. I'd love if you could kind of speak into what you're seeing with this hybrid remote model as well. But maybe you could just give us some tips and tricks in regards to what to pay attention to from time of employment to the potential termination.
Okay. So something that employers are not aware of is that the employment laws, the state and federal employment laws, apply to employers from the time of the job posting, right?
Oh,
So before you even hire the person, you could potentially, you as the employer, could be on the hook for violating some of these employment laws at the time of the job posting, through the interview, through the time of the offer letter, of course, during the time that this person serves as your employee, and potentially after you terminate them. So it's really, it's the entire lifetime, the not the entire lifetime, the entire timeline, basically from the very beginning to the very end of employment with these individuals. So you just, it's so important to be aware of the law and make sure that you're not violating any of them. Something that comes up a lot with the interview process. So let's talk about something that could come up during the interview process, because I saw that you were, you seemed a little bit surprised by that.
I was.
Yeah. So employers have an obligation under the ADA, which is the Americans with Disabilities Act, to accommodate employees and potential employees should they need an accommodation if they have a disability. And this comes up a lot in the interview process. So let's say that you have an applicant that is hard of hearing and needs an interpreter. This is something that the company might have to provide to the job applicant as a reasonable accommodation. Another thing is, during the interview process, if you require potential candidates to take a test on a computer, if your candidate is unable to complete the test in the amount of time or take the test on the computer because of some sort of disability, the employer might have to provide additional time or additional means for this potential candidate. And a lot of times they don't know that because they say they're not my employee, right? I haven't hired them yet. I have no responsibility towards them. But that's simply not the case. It applies to individuals who you are interviewing as well as your employees as well.
Wow. So even if the candidate did not disclose that they have some level of learning disability, because this happens quite often. And, I have so many law firms that have all these testings and assessments and what have you. And oftentimes the candidate will take it. And again, these are not ones that I use in my company and or that I actually even recommend or support, but I can't get them away from a lot of them. And they'll come back and say, nope, can't reject this candidate. It took them too long. They didn't answer it correctly, whatever it might be. Are you saying that even if the candidate does not disclose that they had a learning disability, that the employer could be, in, potential exposure?
No,
No.
no. So it has to be disclosed.
Okay, great.
Yeah. I mean, it has to be disclosed. They have to say, look, I have this issue and I need this accommodation, or I have this restriction, which is preventing me from doing what you need me to do for purposes of the interview. Yeah, absolutely. They need to know. But this is why it's so important to train your managers or the people doing the hiring, because a lot of times, they're unaware, and the person doesn't have to reference the statute, right? They don't have to say, look, under this statute, I'm required to have this accommodation. That's not necessary. So the managers or the person conducting the interview needs to have the proper training to be aware to look out for these things, to kind of issue spot with them.
Wow, that's really fascinating. So, a lot of times people will use recruiters such as myself, and that could get really dicey in regards to the candidate can say, "Well, I told the recruiter, that I had a learning disability," or sometimes the candidate will type up and send us something, we'll forward it to the law firm, and the law firm be like, "Nope, I don't even want to interview them." So, people, listen up, not so quick, as Carly says. Really, I love that you're bringing this up. Talk to us about the job ad before you even interview the candidate and what you see there.
Right. So the job ad can't be discriminatory towards a protected class. And the protected classes are race, gender, national origin, religion, age. So you can't say, I'm only looking to hire 20-year-olds, right? Because that would be discriminatory as to individuals over 40 or older individuals. You can't say that I'm only looking to hire men unless it's for some specific business reason. So you need to be careful not to exclude the protected classes.
Wow, sometimes I'll see not my ads, but I will see ads out there because we always do a side by side comparison. And people that put women only, we're a women only law firm, we're women led. They even have it posted all over their website and posted within their ads too. And I see law firms doing that.
Yeah, that's risky to do that. I mean, unless there's some sort of reason why. So just like you can't exclude women, you can't exclude men, right? So
Right.
that'll go both ways. I think I saw something recently. It must have been a lawsuit, and this it was a male employee, a male, very high level executive employee who said that he was passed over for a minority. They were only looking to hire a minority, and it was a type of reverse discrimination type claim, right? He was saying that he was excluded because of his gender and because of his race. Well, you can't exclude either way just based upon those factors. So I think it was very recent. I think he was awarded a multiple six-figure award for that.
Oh, wow. Wow. Oh, this is so great. Thank you for all these tips from the time of placing your ad. Just be really cautious and clear on that. And then in addition, I love that you brought up assessments because I cannot tell you how many times I have seen the rejection that comes from there, just simply based on some of the things that you are saying. So listen up, people, employers, really pay attention to this.
Right. And you really, the individuals doing the hiring really should keep notes during the interview phase, because there is a cause of action called failure to hire. So individuals can sue the company for not hiring them. And that's based on typically discrimination. So they are going to say, look, I was a female employee, I was very qualified, and you hired the male employee who was less qualified over me. So in that situation, it's tough for companies to defend because they don't have that documentation that we were discussing, right? They may have a couple of notes, but it's really helpful if they have more documentation on the reason why they chose one versus the other.
So are you saying this I see quite often too, when we will take on jobs and we'll find candidates and they'll say, I already interviewed with that law firm, or I at one point submitted my resume there and I never heard back from anyone, or they will give us horror stories during their interview process with this law firm. Can you talk to us a little bit about rejection letters? And if you have any insight or input on that, for example, if you should always make sure you send one for kind of CYA. And then number two, just making certain that the reason for rejection, do you have any insight on that, on what you should stay away from and what you should make sure you include?
Yeah, so I think as a non-legal issue, I think a rejection letter is a nice thing to do so that the candidate knows, if they're waiting to hear back from you, if you are going to turn them down, they're not just sitting waiting around. Maybe they can go look somewhere else or apply somewhere else. Again, that's kind of non-legal. That's just kind of I think a nice thing for a company to do to keep the lines of communication open. But from a legal perspective, so you are not going to want to include in a rejection letter um, that the reason for the rejection was something that was discriminatory. You weren't, and again, this goes to the protected classes: race, national origin, gender, religion, disability, age. I think there's a couple of others that I'm missing. You should not say, um, we are not hiring you because you are pregnant. That's a no-no. And by the way, this comes up a lot. This happens a
Yes,
lot
it
because
does.
think about it. Employers, when they see a pregnant employee or somebody that they might be hiring is pregnant, they're thinking to themselves, this person is going to need to take a lot of time off in the near future, right? You can't make hiring and firing decisions based upon a pregnancy. You should not include in the offer letter, I'm not hiring you because you could potentially, you're a female and you could potentially get pregnant soon. Don't include anything about their gender, their race, their accent, which falls under national origin. I've had a lot of cases about employees making fun of someone's accent. Um, you can't do that. Really don't make fun of employees at all. I mean, that's just not good. But when it falls under one of those protected classes, yeah, that's a really big no-no. So I would stick to the business reasons why they weren't hired in the rejection letter, or just not give a reason at all, actually would probably be the best bet.
Yes. It's interesting as you're bringing up pregnant. I hear that quite often. Another one that I hear is single moms or moms with small children
Mhm.
that, could potentially, oh, their kids are always going to be sick. They're in school age, or they're going to be calling in sick all the time because school's out, especially since this virtual world where people are doing hybrid or online or what have you. I hear that all the time.
Right. So that's going to get you into trouble. And I teach it's an online on-demand course on employment laws.
Oh,
And it
good.
is to train basically managers and people making these decisions. And in one of the modules that I teach, it's exactly with regard to these issues, because the employer needs to know, am I hiring this person? Are they going to be able to come to work? Are they going to be able to come to work on time? What about this childcare situation? Right? Like you just mentioned. So I go through a list of basically do's and don'ts. You have on one column the information that you want to find out during the interview. You want to find out if this person is going to be able to come to the job because they have small kids. You can't reference the small kids, right? There's a different way to say, are you going to be able to meet your obligations as an employee of this company? And that's perfectly fine. That's what you need to say. Are you going to be able to arrive to work on time? These are the hours. Don't reference the kids. Don't reference the fact that they're a female and they need to take care of the kids, because that's just going to lead to potential legal problems down the road.
Oh, wow, Carly, thank you for that one. Tell us real quick where people can learn about your online course.
Yeah, I have a few courses. It's on my website at www.carlywannos.com. It's just my first name, last name. And I think you'll probably include that as a quick
I
link
will
in the
in the
show
show
notes.
notes. Yep. For those of you that are jogging, walking, exercising, it is WANNOS.com.
Yes.
Great. Okay, good. We'll have that in the show notes. So what else? What else would you say in regards to? So now, great information in regards to posting ad number one, the interviewing process, the rejection letter, and then, documentation. And now when it comes time for termination, when you say documentation, Are you saying don't sit down and have a conversation? Because a lot of times people say to me, well, I brought a witness, I brought, my paralegal, I brought this person or what have you, made sure there was a witness in the room, kept it simple, had the information, had them sign the, termination, exit letter, etc. Can you tell us what you mean by documentation? And other than that, what else people need to really be aware of?
Absolutely. So hopefully, if you have somebody that is not performing up to standards, you're going to have some chain of documentation showing that, right? So when you have an employee who is violating company policy, they're not meeting your company standards or doing whatever job they were hired to do, you need to write them up to keep, as I mentioned, this covers 2 points. It's creates that paper trail that you need to show that this person wasn't doing their job. They're arriving to late work every day. They're not meeting those standards. They are calling people names in the hallway, whatever they are doing. But also so that they know that there's a problem, right? So when you do get to the point when you terminate them, it doesn't come as a surprise. At the termination meeting, you can say, look, we have spoken to you 5 times about this. We have told you that, this is the rule you're violating, that you need to improve. You're not improving. You're still doing whatever it is that we have an issue with. And so at that point, we're going to have to let you go. So that is that legitimate, non-discriminatory reason that the company needs when they're terminating an employee. So that's the documentation. And you are meeting hopefully with the employee all along to let them know. So again, so it's not a surprise at the end of the day. So that's the documentation that I'm referring to. And then also at the termination meeting, I think that you mentioned, I go back and forth on this depending upon the facts of, the circumstances that I'm dealing with. Sometimes it's best just to let the employee go and not say anything, not give a reason. But sometimes if it's something that has been ongoing, right, that has been discussed many times and the employee is aware, you obviously can disclose the reason. You don't want the employee to be left wondering, I have no idea why I was fired. That was out of left field. It must be because my protected class. It must be
Yep.
because I'm a female, or it must be because I just, I had a child or what have you. So it's really fact specific, and it depends on the circumstance of whether you're going to actually disclose the reason, because again, in Apple states, you don't have to give a reason. So that's through the termination. And then once the employee is terminated, I want to talk about severance agreements,
Yes.
because that is a really, really effective tool a lot of times. And so a severance agreement is in exchange of a benefit to the employee, typically money, in exchange for the employee signing a release, right? You're giving a payment of some sort, and the employee is promising not to see you in the future. So this is creating the peace of mind for the company to know that they're not going to get a lawsuit when you're down the road. And it also is beneficial to the employee if negotiated properly, because this person might need some money to help bridge the gap to the time that they get their next job, or to help pay some bills because they were just terminated. So it's a really effective document and tool for both sides. And so I typically recommend for clients to consider engaging in that type of negotiation as well when they terminate an employee.
Wow. What about, as you were saying that, what about like 1099? So often people are now using these offshore resources, VA resources. They're using 1099 employees. Talk to us a little bit about what you're seeing there. People that are remote, hybrid, and they may not be under a W-2 traditional format.
So you're either a 1099, which is an independent contractor, or you are an employee. So those are two separate things. And the employment laws do not apply to 1099 contractors.
Oh,
They just apply. Actually, I take that back. For purposes of your employment, I mean, if you have a 1099 contractor who is a vendor, I mean, that's kind of like a separate issue. But for what we're talking about, terminating and separating
Yep.
the business relationship,
Yep.
um, the employment laws don't apply to the 1099 contractors, so they're completely separate. And that's a whole nother
Yep.
podcast episode,
Yep.
Molly.
Great. We're going to talk about, we are bringing you back for that one.
Yeah.
Yes.
So basically the point on that, and we won't get into that
Yeah.
now because it's a whole nother issue, but you need to make sure that you're classifying your 1099 contractors and employees properly under the law, because it's not just the title that you give. So it's one can't be the other and the other can't be the other. You're either an employee or a contractor, and it depends upon the actual work that's being done.
Okay. Okay, great. Yeah, we will definitely bring you back for that one. When you were talking about severance agreement, I'm just thinking like, oh, do you give a severance agreement to 1099
So
people
yeah,
or?
so for the severance agreement, you need to be really careful because you don't want to mix whether this person is an employee or a contractor,
Yes.
right? Because there are certain protections that they have as an employee. And if they're a true contractor, you don't want to call them an employee and kind of cross those paths and make, muddy the waters on that.
Yes. Thank you for that. That I've seen that happen as well. So severance agreements, I really love that because it is goodwill, good faith, and absolute protection for you. To your point, I've heard horror stories of people coming back a year or two or what have you. I mean, and as you were talking about that, that's all you need to see. I mean, social media is infectious and contagious, and you see somebody else posting, and you're like, oh, wait a minute. I think that happened to me too, 2 years ago, what
Yes.
have you. And then I've heard horror stories of people coming out of the woodwork,
Yes,
and
absolutely.
there
And it does
was no
happen.
documentation.
Well, and the problem with that is there was no documentation. The documentation has been lost. The other employees are going to corroborate the employer's side of the facts are no longer there, right? So it's difficult when the claim comes so much later, and you don't have the information that you need at that time. So, yep, the severance agreement, in certain circumstances, will definitely be helpful to create that peace of mind and know that the door is closed with regard to that employee and situations that might come up.
That alone, thank you for bringing that up because I don't know. I would hope that our listeners today would be like, I am implementing that in my exit strategy, in my termination interview, what have you, just for peace of mind, to your point.
Exactly. Yep.
So tell our listeners how they can find, I know you have a phenomenal termination checklist, and how some of their hiring managers, office managers, CEOs, COOs that might not have the classical training in regards to what you offer in your courses. Tell us how we can learn more and find more.
Sure. Well, I have a lot of information on my website. It's carlywannos.com. I have a podcast. It's called the Employment Experience Podcast.
Fantastic.
Thank you. And it is, we just had you on my podcast a couple weeks ago,
Yes,
Molly.
I can't
So
wait.
that episode will be coming out shortly. But it is all about employment law topics, HR management, and it's really informative. So I have that on my website as well as the downloadable courses. They're on the website too. And like I said, they're really good for managers and HR professionals who might be dealing with employees on a day-to-day basis and just might not have the education or knowledge of the different laws that they're dealing with. One of the ones is the ADA, the Americans with Disabilities Act, and this is a federal law that comes across my desk for violations all the time. And it's a little bit more complicated because you're dealing with people's medical issues. And unfortunately, managers just don't know how to respond and address that. So that's one of the courses that I have, along with a couple others. And then I also have contract templates that I prepared. So a lot of companies don't have the time or budget for customized lawyer drafted agreements. So I have contracts that I prepared, and you can download them online, and there are templates so that you can customize them to meet your business needs. And those are all on my website as well.
Oh, great. Give us an example of some of the templates you have there.
So one of the templates is the severance agreement. So this
Great.
is the severance agreement that I use in my practice. It's really helpful because you can actually take this to your attorney. It's not state specific. So if you want it further customizable, you can take it to your attorney and have them customize it for you. It's actually would be more cost effective to do something like that, as opposed to have an attorney draft it from scratch. So there is a severance agreement, an employment agreement, a non-compete and confidentiality agreement. And there is also an employee handbook, but that's Florida specific. So only Florida businesses for the handbook.
Oh, wow. Fantastic. Oh, Carly, thank you so much for being our guest today and providing this wealth of information in regards to terminating employees not so fast.
Absolutely, Molly. Thank you so much for having me.
Oh, okay, listeners, that's a wrap. Until next time, continue to go forth as leaders leading leaders. We've reached the end of another impactful conversation on the Hire and Empower podcast. Whether this was your first episode or you're a longtime listener, I know you can tell I have passion for people. Whether you're a business owner, employee, executive, or hiring manager, I understand the situation you're in. Hiring, onboarding, and leadership is expensive, exhausting, overwhelming, and if that's not enough, it's also time-consuming. My friends, it doesn't have to be this way. There is a team at H&E that has your back. For over 25 years, they've transformed over 4,000 law firms into efficient, effective, profitable assets for their business and made it fun to come to work again. Check out our Smart Hire solution, our employee leadership program, and the 66-day law firm turnaround at hiringandempowering.com.